So today's topic is bidding or negotiation phase risk management, or as stated in the new AIA documents, procurement phase services that you as a design professional could be required to provide to your client, the owner. So what we'll be looking at today will be the services provided by the design professional during this phase. We'll look at some key features that distinguish between public and private project bidding and how the services that you provide may be impacted. Some of the issues that you may face when you're pre-qualifying, recommending contractors to the owner, and some services that you provide and the issues that you face during the bidding period and evaluating bids. And finally, there will be a negotiation phase and an award of construction contract to the contractor by the owner. So just to clarify what the services are provided by you, let's understand first that in this presentation, the bidding or negotiation phase typically begins after you've completed your construction documents. And for the purposes of this discussion, we are in a design, bid, build, project delivery mode. And for demonstration purposes, I think this diagram shows what the contractual relationships are. You, as a design firm, have a contract with the owner, and you're responsible for providing design solutions. And your solution is part of the package that gets bundled into the construction contract between the owner and the contractor as the construction document. So that is what you've provided to the owner. The owner then takes your construction documents, and that forms the basis of a construction contract between the owner and the contractor. The contractor essentially is going to commit to doing this job for a certain amount of cost within a certain amount of time, and they'll be responsible for the means and methods, and assume responsibility for the documents that have been presented to them and say that they will build the facility or the capital asset in accordance with these construction documents. The owner, of course, has taken responsibility for the program and site. They have taken the contract documents and given them to the contractor. And when they provide that to the contractor, they're saying that there is indeed enough information in here, Mr. Contractor, for you to complete the project as stated. So there's something called the Spearman doctrine that says that the contractor is entitled to rely on the information, and that the owner is saying that there is indeed enough information in these documents for the contractor to do the job. And of course, the owner is responsible for timely payment. Note that with this type of delivery system, the design, bid, build, delivery system, the process essentially must proceed in a linear fashion. And we're assuming that is indeed the case, that the construction documents have been completed before a contractor can be selected. Now, owners, of course, do have the option of pre-selecting the contractor before the construction documents are completed, and may actually involve you, the design professional, to work with a pre-selected contractor to help provide the design solution, and that is done with certain clients. But for the purposes of this discussion, we are assuming that the construction documents are something that you have done, and that the contractor is now they're being used. The construction documents are now being used for the contractor to bid or provide proposals to the owner. So, as a design professional, prior to obtaining bids, you are performing these types of services. You are recording information on prospective bidders. You're taking responsibility possibly for distributing the bidding documents, and in this day and age, that could mean that the documents will reside on your servers so that people can download them, or you could say that the documents will be available for anybody who pays a nominal fee at the print shop. Whatever the case may be, you could take responsibility for distributing the bidding documents. You can attend or conduct pre-bid meetings, and this is all prior to bid submittal, and we'll talk in more detail about that later. And prior to bid, of course, you can prepare and issue addenda that will clarify, correct, or change the original bidding documents. Now, all of these services are things that you may undertake before the bids are submitted. Once the bids are received, you can perform several types of services for the owner, but it's important to understand what your role is. You're typically in this phase during the during the procurement phase, you're acting as a limited agent for the owner while performing these services. And your scope of authority for what you can do for that owner, for your agent in this case, is typically defined in your owner design professional agreement. So for firms that are undertaking these types of services to assist the owner, be very aware of what your responsibilities are, what the limits of your authority are, and act accordingly. Your role ultimately is to assist the owner in the selection of an appropriately qualified contractor. And you're not a party to the contract between the owner and the contractor. As we saw in that diagram, the contractual relationships is between you and the owner, you the design firm, and between the owner and the contractor. There is no contractual relationship in this mode between the design firm and the contractor. So ultimately, it is up to the owner to make the ultimate selection of the contractor. Now, the owner may rely on you to provide them with information to help them make that decision, but ultimately, you have to remember that it is the owner's responsibility to select the contractor. So once the bids are received, typically, you are helping the owner by tabulating the bids. You're evaluating the proposals that have been submitted by the contractor based on your construction documents. You're advising on the acceptability of proposed subcontractors and suppliers. So that could be a condition of the bidding documents, that they provide details on how they intend to supply the work. And also, ultimately, you could be responsible for assisting the owner and owner's counsel by preparing and awarding contracts for construction. And your role is really to help with the technical aspects of the preparation of the construction contract. So that essentially is how you provide value to your client by helping them negotiate a construction contract with the contractor. This is indeed one of the most probably expensive things that an owner will have to do. Putting a capital asset into place is expensive, and owners often do ask for assistance from the design firm to help them with that process. And as long as you understand what it is that is asked for you and it is explained in your professional services agreement, then these are services that you can certainly provide. So let's take a look at some of the major differences in the public and private project bidding environment. And as you know, these are two separate worlds really for a particular purpose. In the realm of public projects, these are fairly highly scrutinized contracts that the government enters into. One of the most important powers that a state government or local government has is the ability to award contracts. And that with that comes regulations, with that comes high scrutiny, because that is a tremendous power that they have, and since it's public money, there is interest in making sure that the award process is fair and is compliant with the regulations that have been put in place to protect public money. And oftentimes, the state statutes and regulations establish the bidding thresholds that require a competitive bidding process. The thinking is, and the requirement is, that it is only through a competitive bidding process that the government can get fair value for its money, and that it won't be corrupted, so to speak. So to that end, the government agency is often required to publicly advertise for construction bids. Um, and the contractors themselves want to be sure that they're not just being used as dummies, that the bidding process is indeed fair. So it is subject to very close scrutiny by the contractors themselves to see that it is administered strictly by the rules. Um, so the underlying tenet is that really the process should be fair and without special treatment for anyone. Uh, so with that being said, public officials typically have very little or no discretion to allow any variations from the rules. And as a design professional providing services in this space, you need to be well aware of what those rules are. Um, and it's a competitive process. There's extensive, strictly enforced rules, and that leads to certain types of challenges. For example, you as a design firm may be privy to confidential information about how much the owner is expecting to pay for this facility, for this project. That is something that the owner has, but you certainly don't want to disclose that to the potential bidders because that is confidential information. So those are the types of safeguards that you need to put in place to make sure that you are uh, conducting yourself appropriately. Um, so bidding is open for all qualifying bidders, and we'll talk about if how do you pre-qualify? Is there a notion of a pre-qualified bidder in the construction, in the public phase, in the public procurement, and that really does depend on the state with regulations. But generally, it is intended to be open for all bidders out there who qualify, and in some cases, the qualifications may be quite onerous, or it may be quite open. Um, One thing you have to realize is that based on your particular state's statutes and regulations, you may be required to award the contract to the lowest bidder. Now, that is generally true. I mean, that is the whole point of a competitive process. But there are often provisions that require the owner to award the construction contract to what is called a responsible contractor. And generally speaking, a responsible contractor must possess the necessary financial and technical capability to perform the work as well as the tenacity to do so. And usually that is demonstrated by the contractor's past performance record. And we'll look at ways to help the owner evaluate what particular contractor's past performances could be. But generally speaking, even if the statutes say that the contract should generally go to the lowest bidder, there may be certain requirements that allow the owner to make a different selection if they can show that they are awarding it to what is deemed to be a responsible contractor. So again, these rules really vary by state, and so if you're involved in this type of services, it is really up to you to know what the nuances are, what the thresholds are, and what the requirements are for putting these bidding documents out there. Now, in the private arena, you can certainly use the same type of rules and the same type of expectations and your requirements that you advertise and so on. But it's up to really the owner because there aren't any statutory restrictions on what the owner can do with their money. So you can make, even if you have rules, you can make exceptions or variations to the rules that you've published. The bid list is typically restricted to only those who are invited to bid. And so really for any um, substantial private entity usually has a pre-qualification process to uh, uh, to make sure that the contractors they're dealing with have the capability to do the job, especially for larger clients or larger jobs. Um, so if you're being asked, for example, to prepare a bid list or a list of contractors, it should certainly include names that are suggested by the client. And of course, uh, the client is not, as I said earlier, not required to award the contract to the lowest bidder. If they have reservations about the lowest bidder, or feel like they're not quite qualified, or they're not up to it, they can award it to somebody else. For a design firm working with private clients and involved in this phase, I think it's important to keep the process honest. Do not be involved in a fake bid process that is designed to verify prices or do some free cost estimating on behalf of your client. The owner may not necessarily suffer from this type of activity, but as a design firm, oftentimes working in a very particular community, you may find ultimately that the best contractors will avoid bidding on projects you've been involved with if you are perceived to be not quite honest when you put projects out to bid and then nothing gets awarded because you're using the process to solicit market information at a given time. So even though the rules are not, it's up to the client, I think it's still important that a design firm act honestly and fairly with the contractors who oftentimes, if you think about it, do spend significant resources to prepare a bid in hopes of getting the job. So you certainly don't want to be identified as one of those who abuses that process. So let's talk how you pre-qualify or help the client pre-qualify or recommend contractors for a job. Again, you are assisting the owner. You're acting as a limited agent. But if you're being asked to recommend or pre-qualify, you should, of course, only provide factual information, and with the caveat that the client should understand that past performance is really no guarantee of future performance. We do rely on past information, past performance of the contractors, but that's not to say or give the owner the impression that their particular project will go smoothly. Construction is inherently in certain undertaking. There could be a lot of different things that occur during construction, and some of those risks are still with the owner. So it doesn't mean that a recommended contractor won't have any issues. But fundamentally, what you're looking at is, do they have the financial stability to fund the project? The ability to mobilize onto a construction site, have qualified personnel working on it, and staff the job accordingly does require resources on the part of the contractor to be able to do this job. So their financial capability is important. Just as important as the technical expertise to successfully complete the project on time and within budget. And that's a key consideration as to whether a contractor is qualified or is worthy of recommendation. Does the contractor have sufficient insurance to cover potential losses caused by the employees or subcontractors? Again, that is the key consideration for the owner. And finally, I think you should always think, into the owner at least should be thinking in terms of what's their safety record? Do they have a culture of safety? So what are some of the ways of actually obtaining information to be able to make this type of pre-qualification or recommendation to the owner? And the owner should understand that if you pre-qualify the contractors before they're permitted to submit bids, it really is an effective risk management tool for the owner. You can assess the owner can assess the interest in the project by qualified firms. You can reduce the amount of time that you take, Mr. Owner, in evaluating bids submitted by unqualified contractors. You can reduce your problems associated with artificially low bids submitted by contractors that may not be capable of performing successfully, and it saves you a lot of time in having to evaluate, do they know what they're doing? If they're already pre-qualified and you've looked at their capabilities, you have a much higher chance of obtaining reasonable bids for your project. So, of course, the owner can obtain contractor credit information. That's usually done from an organization like Dun & Bradstreet. That gives you a good indication. You can use contractor questionnaires. Require the contractor to respond to some questionnaires designed to elicit information that gives you an idea of what their capabilities are. Some of the things that you may find useful to ask is, how many years has the contractor been in business? What's the ownership structure? Is it a company? Is it a limited liability company? Is it a partnership? What's the list of jurisdictions and trade categories in which the contractor is legally qualified to do business? What are the categories of work that you, Mr. Contractor, normally perform with your own forces? Have you ever failed to complete any work awarded to you? Are there any judgments, claims, arbitration proceedings, or suits pending or outstanding against the contractor? Has the contractor filed any lawsuits or requested arbitration with regard to construction contracts within the last 5 years? List the major construction projects you have in progress. List the major projects you have completed in the past 5 years. You can always ask for, of course, a list of references. A financial statement is often asked in a contractor questionnaire. Ideally, you want the financial statement to be audited, but you could ask for the latest balance sheet and their income statement. And then finally, a list of OSHA violations is also often asked in contractor questionnaires. There's a lot of important information in the responses to the contractor questionnaires. Obviously, if you are privy to this information, you're expected to maintain confidentiality. But really, these are some of the ways in which the owner can get reliable information to pre-qualify the contractors that would bid on their projects, or for you to recommend contractors to the owner. And then finally, of course, you can visit active contractor projects to see if they are really who they say they are, and if they do show that they can run a construction project in a competent manner. So recommending contractors can present challenges, and there are some risks. Your client can take legal action if you negligently provide positive information about a contractor. So, if you are performing research on behalf of the client, and there's information out there that, if you had done your job, would have come to light, but you failed to pick it up, that could expose you to a claim that you were negligently performing those services. Or your failure to report past poor performances. Similarly, you can also face a claim from a contractor, and we've actually seen this in our program where a claim could be made. It's pretty rare, I think, but a contractor can certainly say that you, the design firm, actually defamed the contractor when you made a recommendation to the owner that they don't proceed with a particular contractor, or that you interfered with a business relationship, and that is actually a tort in a few states that allows them with a cause of action to proceed against you. So ultimately, to safeguard yourself from these types of claims, there really should be no malice or ulterior motive behind the negative opinion. And always rely on factual information and investigate the underlying facts so that your recommendation is reasonably supportable. And if that is indeed the case, you really do have a way to provide yourself with a defense if you're facing this type of claim. So, having said that, the next really point we want to talk about is the bidding period and evaluating bids. And oftentimes there's extensive instructions that are put together in the bid package, and we'll talk about these. But essentially, they are, your bidder's representations, the availability of documents, rules for interpretation of the documents, and so on. And so let's talk about these. The bidder's representations really are important because it's a statement by the contractor that they understand the bidding documents and that they have done their due diligence, they have visited the site. And this is an important basis on which you can rely on if they're making an offer, if they're bidding, that they indeed are willing to undertake the risk. The availability of documents, where are they? How can they get their hands on them? Is it on your server? Is it at a print shop? And so that is important, and and it's well defined as to who may receive documents and so on. So it's important that that information be there. Of course, in the instructions, there are rules for interpretation of the documents, procedures for questions and answers about the bidding documents, and that is indeed an important part of being able to clarify what is in the documents and issue addenda, as we'll talk about in a moment, about what the documents mean. You, as a design firm and the owner, certainly wants to make sure that the bids are easily comparable. And for that reason, the form, style, and the way the bids are submitted are specified in the instructions. Otherwise, it would be very difficult to evaluate what the contractors are proposing if everybody is allowed to submit on their own form. The owner, especially in a public setting, wants to make sure that that if somebody whose bid is awarded the contract, that they will actually sign the contract. So oftentimes a bid bond is required, and if they are tendered the contract but they refuse to sign, then the owner may collect on that bond, and usually what I've seen is about 10% of the contract amount. And the intent is that if the owner goes ahead and awards the contract, and the bidder decides not to sign for whatever reason, then the owner has some way of recovering for the amount of inconvenience that they suffered in having to reopen the process and award the contract to the next bidder. Payment and performance bonds may also be required. That is often also in the instruction documents. And finally, the rules for modifying or withdrawing a bid may also be included. And generally speaking, and we'll talk about this as well, bidders are allowed to amend or withdraw a bid if there are clerical or mathematical errors. Of course, especially in a public setting, this is important that the procedures for opening and announcing the bids and the client's rights are also included in the instructions to bidders, and there may be specific administrative details that are project specific. it is important that really all bidders feel that the process is open and fair, and that they are participating in a legitimate exercise to try and win the bid, and that it's just not a procedure that, with a predetermined outcome. Of course, in a public setting, in a public project setting, all of this is really defined by the statutes and regulations that govern the process. So, for a firm providing these services, pre-bid meetings are often required, and owners often require this as a precondition for all bidders, so that if you didn't attend the the pre-bid meeting, you're not allowed to submit a bid. They can be very helpful in minimizing confusion and consequent claims by bidders. So, during the project, during the meeting, key comments and questions pertaining to the project are received. The important requirements of the contract are stressed, and it helps to minimize confusion. It also helps weed out last-minute bids by contractors who have not participated in the process and are putting together really a proposal in the hopes of winning something without having done the detailed work and study that is often required to provide a meaningful bid. So that is why pre-bid meetings are really an important risk management tool for the owner. So if you are indeed in charge of running a pre-bid meeting, you should keep meeting minutes and distribute to all in attendance. Obviously, make note of who attended and make sure that they sign in appropriately so that they are indeed accounted for. And then after the pre-bid meeting, you are indeed oftentimes expected to issue addenda based on the questions and discussions at the meeting that make sure that everybody is on the same page and it is clarified as to what the requirements are for the construction project. And this is oftentimes done during the bidding period. So you want to allow adequate time for receiving and evaluating questions or proposed substitutions. Usually, substitutions are not permitted in the bidding phase because allowing them would put competitors on an equal basis for comparison. So if one party is allowed to do substitutions and others are not aware that there are substitutions, it really does become an uneven comparison because the other competitors may have indeed arrived at a better price if they knew about the substitution. But if it is permitted by the bidding documents, then you should, as a design professional, consider requests for substitutions, evaluate them, and you prepare and distribute the addenda identifying approved substitutions to all prospective bidders. This helps avoid misunderstandings, and it helps the owner evaluate all of the proposals that come in, and everybody is providing bids based off of the same information. So you should obviously receive all questions in writing to avoid misunderstandings. That's pretty basic. You should, if attendance at, if there is a pre-developed bid list, however that's defined, you should allow questions from bidders on the bid list only. From a management standpoint for your firm, you should consider designating just one person to receive all questions. And so, make sure that all bidders have access to the same information at the same time. And finally, and this has to be stressed, no oral interpretations or approvals should be given to any party. Obviously, that could lead to confusion, and it really is unfair to those who are not privy to your explanation. So the communication should come to you in writing, and you should respond in the form of addenda to all bidders to make sure that everybody's on the same page. This obviously is just some suggested guidelines, but typically you tell them, this many days before the due date for the bid, questions should be provided that allows you to issue written addenda and provide that to the bidders, and then finally they use that to base their bids on. Of course, due dates may be postponed when last-minute questions are posed and you feel that these are important questions that need to be addressed, so that is always something that can be done. These numbers here really are just numbers that are suggested. Obviously, depending on what is appropriate for a particular project, this should be amended accordingly. So when you're issuing the addenda to the construction documents, they should be communicated to all bidders simultaneously by written addenda. When a contractor is preparing a bid, they're often waiting to gather information from their suppliers and subs. So there's often an element of being rushed, especially towards the end, because they're waiting to gather information from their subs who are themselves engaged in a competitive process to try and win the job with their general. So it's always important that, at least from your end, you are providing the bidders with a level playing field and make sure that everybody is able to access the information that you are providing as addenda simultaneously. When the bids are received, you need to allow enough time to evaluate before awarding the contract. So you should always look at this. When you receive bids, obviously you now have access to what the various contractors think the job is going to cost, and you can tell what the numbers are, what the spreads are, who the lowest bid is, and so on. Generally, if a contractor has a very low bid compared to the competitors, you should really scrutinize it carefully to make sure that what they're proposing isn't based on a clerical or mathematical error, because if that is the case, then oftentimes they are allowed by law to withdraw the bid without consequences. Especially in a public procurement setting, oftentimes everybody's bid numbers are disclosed, so the contractors can tell, who the lowest is and by how much. And so, if it does look like they made a mistake that is mathematical or clerical, oftentimes, the courts, by a matter of law, say, you're able to withdraw the bid, and there won't be any consequences. If the mistake, however, for such a low bid is based on one of judgment or lack of expertise, that is generally considered a business risk that the contractor has taken on, and there will not be the mistake will not relieve the contractor from performance. You, in that case, may be called on, as well as the owner's legal counsel, to determine whether the mistake is clerical in nature or a mistake of judgment. And if the owner refuses to allow the withdrawal of the bid, if the contractor wants to withdraw the bid, the contractor at that point is faced with two options. They can perform the project at the mistaken bid price, or they can refuse to sign the contract. And of course, if there's a bid bond, then that's the risk forfeiting the bid bond. So those are some of the situations in which, when you're evaluating a bid and you have one that is low, there may be additional wrinkles in resolving that particular issue that you should be aware of, especially in a public setting where the amount of the bids are oftentimes public information. On a private project, you may choose, the owner may choose not to award the project to the lowest bidder because there's little difference between the bids, or there may be prior experience with one of the bidders, and the client may be comfortable with that particular contractor. Um, or if they think that there's a judgment error in the lowest bidder's bid, even though they could contractually hold that lowest bidder to that proposal, they may be better served going with a bid that they feel is more um, reflective of what the actual costs are. And in the long run, the client may make the decision that it's better to go with somebody who seems to have a better grasp of the job rather than trying to squeeze savings from a contractor who may not quite have all their ducks in a row. All of that to say that on a private project, the client certainly does have a lot more leeway on how to proceed once the bids are come in. So now that you're evaluating the bid, the next phase typically is to negotiate and then ultimately award the contract. Now, just when it comes to negotiation, realize that if the changes are negotiated before the award of contract, that it is issued as addenda. You haven't awarded the contract, you're negotiating changes, and so that is still an addendum to a proposed contract. If changes are negotiated after award of contract, then they're issued as change orders. Just be aware that, especially if you're in a public setting, you don't want to. The owner should certainly be aware that there could be concerns about negotiating changes so soon after the contract is awarded, because it could be that, hey, these guys were allowed to submit a qualifying low bid and then subsequently change the nature of the job so that they were awarded more money without the benefit of a market without the benefit of a competitive process. So there's always the potential that the scrutiny from your competitors may lead to issues for the owner. But ultimately, you are, helping negotiate with the contractor in your role as a limited agent. And of course, you should be aware that if there are negotiations and there's changes, oftentimes that could mean changes to the construction documents are required to reflect what the subject of the negotiation is. But if it's just a matter of money or how funds are allocated throughout the project, you may not be required to change the construction documents. So you may conduct these negotiations, as I said, as an agent of the owner. Recognize the difference in role when you're acting as the agent of the owner, and later on during construction when you're acting as an independent consultant to the owner. There's a different role that you have depending on the phase, and it's important to keep that in mind as you provide services to the owner. If you are indeed negotiating with a contractor on the owner's behalf, remember not to adversely affect your role as an impartial judge of the performance during construction by the owner and contractor. In other words, you don't want to be overly aggressive in a way that jeopardizes your ability to impartially judge what the rights are between the owner and the contractor during construction. And especially if you have a prior relationship with a contractor, be alert to potential conflicts of interest or the appearance of impropriety, so that it's not alleged that indeed you were too lenient on the contractor because of ongoing relationships or prior relationships or expected future relationships with the contractor. So it's always important to be able to act in a manner that is fair both to your clients and to your reputation in the community, so that people dealing with you are comfortable in your role. Now, of course, the final step oftentimes is, you're preparing a client-contractor contract. And this is something that, especially, for firms working in smaller jurisdictions, you may be the only person in reality who touches the client-contractor contract. But be aware that the owner should understand that you're not an attorney, and only lawyers may prepare the client-contractor agreement. And really, to emphasize that point, all of the standard form documents warn the client that the owner should engage legal counsel before using these documents. Your role is to assist with technical and practical advice, and really, that is your role. You're a design professional. You're oftentimes licensed to perform these services. And when it comes to the preparation of contracts, your role is to prepare the technical aspects and provide guidance on that issue. If they do not engage legal counsel, document the advice that you've given them that they should engage legal counsel. The owner can always decide to act as their own attorney. That's perfectly within their rights. There's no, they don't have to hire an attorney. But if they don't, make sure that the services that A, you've told them to hire an attorney, and B, that they understand that they're acting at their own risk when they proceed with that. And state affirmatively that your advice is not a substitute for legal counsel. So the last thing that we want to touch on is making sure that you actually have an executed copy of the client-contractor contract. This is important because you may not be there in the room when they actually sign the agreement, and really, between the award and the execution, things may have been added, deleted, or changed as the contractor negotiates, and you want to be aware of what those changes are, because you ultimately want to make sure that your role, as described in this contract, in the owner-contractor contract, is consistent with your role described in your contract with the owner. So the only way really to make sure that the changes that they may have negotiated after award of contract don't affect your scope of services is to make sure that you do have a copy of that, and you compare how your role is described, and furthermore make a determination if there have been any changes to the contractor's obligations that were stated in the documents that you help prepare. Ultimately, again, you're providing a bridging service between your completion of design services and the start of construction services. And before the start of construction, before the construction starts, the owner in a design bid build has to engage a contractor to actually build the physical facility. And that's really that's the key area which you're providing services in. And you want to make sure that you're able to provide these services and be aware of any ground rules, especially in the public arena, or any rules that the owner has set out, and help the client meet their objectives. For more information, we urge you to visit our website. Here's a look at our new website. If you have not already established an account, you should do so. Once you register, you can view claim studies, practice management information, contract language and commentary, past webinars, which can now provide CEUs, and much, much more.